same-sex couples benefits, including stability, attendant to marriage. Proponents failed to put forth any credible evidence that married opposite-sex households are made more stable through Prop 8. The only rational conclusion in light of the evidence is that Proposition 8 makes it less likely that California children will be raised in stable households. Proponents next argue that Prop 8 protects the First Amendment freedom of those who disagree with allowing married couples, the marriage for couples of the same sex. Prop 8 does not affect, there's a lot more here, and the judge eventually decides that Prop 8 does not affect any First Amendment right or responsibility of parents to educate their children. That's all I had. But the language time and again throughout the Prop 8 stuff echoes the stuff from the Massachusetts case, right, that continues to say that you can't pass a law that treats citizens of the state or of the country differently if they're similarly situated.
Yeah. I
mean, that's the gist of it. And it may be unpopular in some places, but, you know,
too bad.
Yeah, too bad. Historically, there have been marriage restrictions, and actually, let me find the example here, because it's actually a really interesting one. From the from the Massachusetts case, I keep doing that, where he talks about, where the judge in Massachusetts, here we go, and this is about, this ruling was about finding Section 3 of DOMA, and I should give the background on that real quick.
Okay.
DOMA, one page. One page.
Yes.
A handful of words. In 1996, this act may be called the Defense of Marriage Act. Section 2 of DOMA says that no state, territory, or possession of the United States or Indian tribe shall be required to give effect to any public act, record, or judicial proceeding of any other state, territory, possession, or tribe respecting a relationship between persons of the same sex that is treated as marriage under the laws of such other states, territory, possession, or tribe, or a right or claim arising from such relationship. So this, in sum, says that no state has to recognize a same-sex relationship that's defined by another state.
Right.
Section 3 of DOMA is what gets called into so much question, and that says, and that's really short too, in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or wife. That's all of DOMA.
Yeah. The dreaded DOMA.
That's it in its entirety.
Which needs to go away.
Well, and which has been declared unconstitutional by the district court. In sum, this court is soundly convinced, based on the foregoing analysis, that the government's proffered rationales, past and current, are without footing in the realities of the subject addressed by DOMA, and when the proffered rationales for a law are clearly and manifestly implausible, a reviewing court may infer that animus is the only explicable basis. Because animus alone cannot constitute a legitimate government interest, this court finds that DOMA lacks a rational basis to support it. This court simply cannot say that DOMA is directed to any identifiable legitimate purpose or discrete objective.
Yeah.
So
nicely put.
But the example I wanted to give here, when it comes to marriage and how marriage is strictly the purview of the state, and states all around the country have different rules and regulations. Right. The judge in his ruling says, for example, a 13-year-old female and a 14-year-old male who have the consent of their parents can obtain a valid marriage license in the state of New Hampshire. This court knows of no other state in the country that would sanction such a marriage. The federal government, however, recognizes it as valid simply because New Hampshire has declared it to be so.
Interesting precedent, isn't it?
You know, and they point out in one of them, and I've lost which one now, that that there's no precedent to deny someone marriage simply because they didn't used to be able to be married.
Right. Because
every heterosexual couple, due to age limitations, was at some point unable to be married.
Right.
Until they reached an age of consent, or an age with parental consent, that state would allow them to be married. And just time after time after time, every time judges are asked to look at the question of equality, they say continually that you cannot draft laws that create a distinction, that create two classes of people that are going to be treated differently under the law if those two classes are otherwise similarly situated.
Yeah.
So, that's a mouthful.
Indeed, but that's really good, and it's really wonderful that it's wonderful to hear this language coming out. It's wonderful from judges. It's like finally, it's sort of like yeah, let's make some sense. This is the way it's supposed to work.
Yeah. So Proposition 8's been found to be unconstitutional. And that will no doubt make it to the Supreme Court and have some reverberating effects.
Yeah, clearly. We want it to go to the Supreme Court.
The Massachusetts case that affects DOMA, he actually had, because I have read through his ruling, it's shorter, only 39 pages.
But we won't read it.
We won't read it all. Just a couple of highlights. He actually uses, as you heard in his conclusion, when he blames, when he comes to the conclusion that the source of DOMA in 1996 was animus.
Right. I could have told you that.
He has some pretty strong language. He repeats throughout this. The Constitution neither knows nor tolerates classes among its citizens. It's with this fundamental principle in mind that equal protection jurisprudence takes on governmental classifications that affect some groups of citizens differently than others. To say that all citizens are entitled to equal protection of the law is essentially a direction to the government that all persons similarly situated should be treated alike. This is fun. This is interesting for DOMA. The House, there was a House report, I think it was 2004, they found that there's 1,138 federal laws that are affected by the definition of marriage or spouse.
Yeah, that's a lot of laws.
1,138. The agencies that administer those programs never got to testify, never got any input on DOMA. It happened without their say in it. But at the time, in 1996, Congress asserted that there were 4 objectives when passing DOMA. 1, encouraging responsible procreation and childbearing. This is the reason that we have to define marriage federally between a man and a woman. When it comes to Medicare benefits and veterans benefits and citizenship, encouraging responsible procreation and childbearing. 2, defending and nurturing the institution of traditional heterosexual marriage. They're institutionalizing this at the federal level. Defending traditional notions of morality, and 4, preserving scarce resources, which revolves around government agencies actually having to process claims to the paperwork, the administrative costs of processing same-sex, claims from same-sex couples. The judge in the Massachusetts case, I won't read them all out, but he takes them one at a time and soundly eviscerates each one of them as having no discernible merit to actual governmental interest. What remains, therefore, is the possibility that Congress sought to deny recognition to same-sex marriages in order to make heterosexual marriage appear more valuable and more desirable. But to the extent that this was the goal, Congress has achieved it only by punishing same-sex couples who exercise their rights under state law, and this the Constitution does not permit. For if the constitutional concept of equal protection of the law means anything, it must at the very least mean that the Constitution will not abide such a bare congressional desire to harm a politically unpopular group. He points out that the government has, when they were taking on this case, said, the reasons that it got implemented in 1996, we accept that they're bogus. Throw them out. But we have good reasons we want to keep it now.
Yeah, here we go.
So right off the top, they already accept that the reasons it got put in place, those 4 that I read, are bogus.
Clearly bogus, yeah.
So the court next turns to the potential justifications for DOMA that the government now proffers. The government argues that the Constitution permitted Congress to enact DOMA as a means to preserve the status quo, pending the resolution of a societally contentious debate taking place in the states over whether to sanction same-sex marriage. The judge points out that prior to DOMA, federal law simply incorporated each state's marital status determinations. There can be no dispute that the subject of domestic relations is the exclusive province of the states. And he goes at great length going through all the history of how states, even before we had a constitution, were responsible for defining marriage.
Right.
When the Constitution was set up, there was no talk of making that a federal responsibility. The government is entirely at the whim of the state in determining who's married. Congress does not have the authority to place restrictions on the state's power to issue marriage licenses, which DOMA doesn't. It just says we won't recognize it.
Right.
Marital eligibility for heterosexual couples have varied from state to state throughout the course of history, and yet the federal government has fully embraced these variations and inconsistencies in state marriage laws by recognizing as valid for federal purposes any heterosexual marriage which has been declared valid pursuant to the state law. That's the crux of the argument. The government suggests that the issue of same-sex marriage is qualitatively different than any other historical state-by-state debate as to who may be allowed to marry, is the argument. However, the judge doesn't find that. He says, importantly, the passage of DOMA marks the first time that the federal government has ever attempted to legislatively mandate a uniform federal definition for marriage or any other core concept of domestic relation. This is notwithstanding the occurrence of other similarly politically charged, protracted, and fluid debates at the state level as who should be permitted to marry. And he gets into the issue of interracial marriage and interfaith marriage and marriage ages.
All right.
He says time and time again that the states are the only ones who can define marriage. But then he gets here to this point. The states are alone empowered to determine who is eligible to marry, and as of 1996, no state had extended such eligibility to same-sex couples. In 1996, therefore, keep in mind that the newly proffered reason for DOMA is to keep the status quo.
Right. Yes.
In 1996, therefore, it was indeed the status quo at the state level to restrict the definition of marriage to the union of one man and one woman. But the status quo at the federal level was to recognize for federal purposes any marriage declared valid according to the state. Thus, Congress's enactment of a provision denying federal recognition to a particular category of valid state-sanctioned marriage was, in fact, a significant departure from the status quo at the federal level. He goes through to effectively, tear them a new one, time and again.
I like this judge.
As noted above, eligibility requirements for heterosexual marriage vary state by state, but the federal government nonetheless recognizes any heterosexual marriage which a couple has validly entered pursuant to the laws of that state that issued the license. He goes on to point out, and this sort of bears on the scarce resources, federal agencies are not burdened with the administrative task of implementing changing state marriage laws. Rather, federal agencies merely distribute federal marriage-based benefits to those couples that have already obtained state-sanctioned marriages. This task does not become more administratively complex simply because one of those couples are of the same sex. Nor does it become more complex simply because some of those couples applying for marriage or marriage-based benefits were previously ineligible to marry, even